Good morning. Thank you for joining us on the last in the series of Brexit webinars. This one is on Brexit and intellectual property, hosted by Simon Barker, partner in intellectual property, and Iona Silverman, partner for intellectual property. Before I hand you over, if you've got any questions for any of the panelists, please use the Q&A function at the bottom of your screens. If there's any technical issues throughout, please use the chat function and I can answer these. I'll hand you over to Simon. Thank you very much.
Thank you, Tom. Good morning, everyone, and thank you for joining us this morning. We're going to cover a number of areas. Not all of it may be relevant to you, but we've tried to keep it as broad as possible, so there's something in there for everybody. In short, we're going to cover the effect of Brexit on trademarks, on registered designs, on unregistered designs, on copyright and database rights, on GIs, on customs enforcement, on exhaustion of IP rights, and some top tips on drafting IP contracts post-Brexit. So Tom, if you give us the next slide, we'll start off with trademarks. So the main impact of Brexit in relation to trademarks has been in relation to EU trademark registrations. And after the 1st of January 2021, these are no longer afford protection for trademark owners in the UK. However, the good news is that the UK government has decided to preserve these rights in the UK by creating equivalent UK rights with all the same filing dates, priority dates, and the same goods and services, effectively cloning the EU trademark right that was in existence or remains in existence. There has been no cost in doing this, and that means, and it also means that no rights will be lost. People commonly refer to these new UK rights as daughter rights, and they can be found on the UK IPO database. They were all cloned on the 1st of January. Those which you come across, which are prefixed with the UK 009, are daughted from the EU trademark rights, from unitary rights. And some others you'll spot which are prefixed UK 008, and these are EC designations of international rights that are daughted. Pending applications have not been cloned automatically. So if you have any pending EU trademark applications, these are not included. But the government has provided for a 9-month grace period in which you can apply for UK rights, subject to payment of a fee. And these two will preserve the filing dates, any priority claim. Effectively, this means that you have until the 30th of September 2021 in which to file for the UK right. Generally, these measures have obviously been welcomed by rights holders because it means that no rights have been lost on Brexit. That said, in future, separate applications will be needed to cover both the UK and the EU, and that will be at additional cost. There will also be additional costs on renewal of registrations because obviously each of them are separate and will need to be renewed separately. That is unless the daughter right is from an EC designation of an international registration, because these can be merged back into the international registration and renewed as a whole, the international registration. So it's probably worth looking to see whether or not you've got any of those. Tom, can we have the next slide? One thing to note in relation to trademarks is that they are vulnerable to revocation if you don't use them for 5 years. And whereas genuine use in the UK would have counted towards use of an EU trademark previously, now it won't. This may be a common scenario in the UK for many businesses who have EU trademark rights, but have only used them in the UK. Whilst use in the UK before was enough to preserve the EU trademark rights, in the future it will not be. So trademark holders will have to ensure that they use their marks both in the EU and the UK if they want to preserve both rights in the longer term. However, there is going to be some time to review this because use in the UK up to the 31st of December 2020 will continue to count for the EU registration until it's no longer seen as sufficient. So in theory, it might carry through to the 31st of December 2025, but more likely it will be sometime earlier. The UK government's position is a little clearer because use in the EU before the 1st of January 2020 will count to use of the UK daughter right. So if you have sufficient use up to the end of the transition period in the EU, that should see you through to the 31st of December 25. So on trademarks, the thing to do is to check if you've got any pending EU trademark applications, see if you want to file for the UK rights. If you've got any EC designations for international registrations, consider merging them back so that you can benefit on renewals. Review your use requirements if you want to maintain use and how you're going to evidence sufficient use, because that will be important. And also it's probably worth reviewing any watching services that you have in place, because you'll need to check that they're fit for purpose as well. Tom, can I have the new slide, please? So on to registered designs, and registered designs, the position is similar to that of trademarks. Registered community designs and unregistered community designs will no longer be applicable in the UK from the 1st of January 2020. But all registered community designs have been cloned in the same way as EU trademarks, making them effectively re-registered as UK registered designs with the same application, registration and priority dates, if applicable. So again, it's good that the UK government here has ensured that no rights have been lost. The position with EU pending applications or applications with deferred publication, these can be filed as UK RDs within the 9 months in the same way, and again you can claim the same filing dates and priority dates. But any deferment of publication that you might have had will be allowed for a shorter period in the UK, because the UK only allows for 12 months, whereas the EU allows for 30. Going forward, again, you'll need to apply separately, and there'll also be separate renewals in the case of registered designs. That's every 5 years. So now we're going to talk about unregistered designs. The position here is slightly more complicated. The UK already has its own form of protection for unregistered designs, called the UK Unregistered Design Right. That will continue for qualifying designers in the UK, but the scope of a UK Unregistered Design Right is not as broad as the unregistered community designs, which will no longer have effect in the UK from the 1st of January 2020. Just to recap, UK Unregistered Design Rights covers only the shape and configuration of designs and not the surface decoration, the colour or materials like prior designs. Whereas UK Unregistered Design Rights must be original, and not copied and not commonplace. In other words, the UK's form of own protection doesn't exactly cover what the community version does. Therefore, with the advent of Brexit, the removal of unregistered community design protection means that there was potential for a number of designs that would have benefited from protection under the unregistered community design that will be left without protection. So to plug the gap, the UK government has decided to create 2 new rights: the continuing unregistered design, which will continue to protect in the UK what would have been protected by an unregistered community design. The continuing unregistered design will last until the end of 3 years, the 3-year term for which the unregistered community design would have been applicable. For designs that are first disclosed in the UK after the 31st of December 2020, these will automatically be protected under the new supplementary unregistered design right. So this is the UK's equivalent of the unregistered community design that's been put in place. And these will last for 3 years in the same way as unregistered community designs from the date of disclosure. All of that sounds great, but there are consequences from these changes, because designs first made available to the public outside of the EU will not be entitled to unregistered community design. So for unregistered community design protection, you will need to first disclose the design in the EU, because the supplementary unregistered design, the UK equivalent, is an equivalent right qualifying for the supplementary registered design, and that needs to be disclosed first in the UK. So you effectively have 2 mutually exclusive regimes, depending on where you first disclosed the design. You might say, well, what happens if you disclose the design simultaneously, perhaps because you launched the product online? And the position there is somewhat unclear. Nobody knows at the moment what the position will be. So if designers want protection in the EU and the UK, for now it will be necessary to decide where first to disclose the design and consider registration in the other territory or register both the EU and the UK. So if designs are significant for your business, it's worth reviewing your strategy here. It is potentially quite complicated. And I think what it means is that registering designs might be more important than ever, because you won't just be able to rely on the unregistered community design. Certainly it would pay, I think, to adopt a more thoughtful approach as to where you first disclose your design and where you want to register it. I'm now going to hand over to Iona, who's going to say something on copyright and database rights. Iona.
Thank you, Simon. I hope everyone got their heads around designs, because I find designs complicated at the best of times. So I think Brexit has only made them even more fun. But I'm going to talk about copyright and then a little bit about database rights. And I'm going to start by saying the basics of copyright law has remained unchanged, which is great news. But I think we all know that copyright is desperately evolving to try and keep pace with technology. And all the changes that are made at the moment are with that in mind. And so, of course, there are some changes that Brexit is going to have an impact on. The first one to mention briefly is around the test for copyright. What is a copyright work? What's an original work? Prior to Brexit, we had the EU regime of the author's own intellectual creation, which was the test for copyright work across the EU, ? Certainly there were some CJU cases that seemed to imply that was the case, but in the UK we were still relying on our test, which was that a work had to be one of the 8 categories of work in order to be protected. And I think we were edging closer to a position where the UK courts would have had to consider that EU test and consider whether it applied in the UK. And now that we've Brexited, I think we've fallen away from that. And whilst CJU case law will remain persuasive, it won't be binding in the same way. So actually, I think we will stay with our 8 categories of protected work, which is maybe good news for clarity in terms of knowing which test applies, potentially bad news if you are a business that is trying to use copyright to protect something that doesn't neatly fall into one of those categories. So that's the first point. The second point I wanted to make was around the copyright directive. So the EU member states have to implement the copyright directive by the 7th of June 2021. The UK really pushed for that directive and was instrumental in getting it over the line and casting a decisive vote on getting it over the line in the EU. However, since Brexiting, the government's decided that actually in the UK we won't be implementing the directive. So having really pushed for it across the EU, they've decided actually no, we don't want it, thanks. So that means that Article 15, which is the press publisher right, which is the right that gives press publishers the ability to enforce copyright in their work and not just rely on a copyright in their author's works. So that won't apply in the UK, which will leave a bit of a gap for press publishers who are looking to fight the fight against news being published on social media and news aggregation sites, which is a really hot topic everywhere in the world at the moment. And the other article that's quite contentious that won't apply is Article 17, which is the article that gives liability to content sharing service providers, i.e. social media sites, YouTube, Instagram, Facebook. They will not get authorization from copyright holders. So if they don't have authorization from copyright holders, they will have to take down infringing content. So it imposes a bit more of an obligation on them, and we won't have that in the UK, which means there'll be a bit more freedom for those kind of sites than there might be elsewhere in the EU. I also wanted to mention the portability regulation. So this change may well have more of an impact on your personal life actually than your professional one. I don't know, it depends what business you're in. The EU portability regulation was the regulation that allowed consumers across the EEA to access their home online content services, so their Netflix accounts or their Amazon Prime accounts, when they travel within the EEA. So prior to Brexit and prior to the pandemic, if you went on holiday to France, you could sit on holiday and watch your content from your Netflix account, and that would be the same content that would be accessible to you in the UK because you would port your account across. Now, from the 1st of January, the EU portability regulation ceased to apply to UK EEA travel, and in the UK, the regulation has been revoked. So that means that your service providers don't need to provide content ordinarily available in the UK to you when you are on holiday or traveling for business in another country in the EEA. That's not to say they can't choose to do that, of course, but content licensing being so complicated and so driven by territory, I find it really unlikely that unless they're forced to do it, that they would do it. So that's one impact of Brexit on copyright. I also wanted to sneak in here a quick word on the database directive and the rights that apply. The database rights are another one of those complicated ones. Unless you use relatively regularly, you can sort of slip out of quite easily and forget how they work. So just as a reminder, you can have copyright in a table and you can have copyright in a database. But what we're talking about here is the sui generis, so the specific database right that applies to the contents of databases rather than the form. The database right was introduced by the database directive, and that was implemented in the UK through the Copyright and Rights in Databases regulations back in 1997, so a long time ago. And the sui generis right does remain valid in the UK. However, only databases made by EEA, nationals, residents, or businesses are eligible for the EU database right. So that just means that if you're a UK business and you do rely on database rights, you can no longer rely on those across the EEA as you used to. So you will need to have an EEA presence in order to be able to claim a right in the EEA, which I suppose is kind of logical from Brexit, but I thought still worth just flagging. If we move on to the next slide, thank you. I wanted to talk about geographical indications and how Brexit is impacting those. So just by way of reminder, a geographical indication, or a GI, is a sign that's used on a product to denote that the product is manufactured in a specific origin and possesses specific qualities that flow from that origin. An easy way to understand that is that a Melton Mowbray pork pie has to be made using a traditional recipe and within the vicinity of Melton Mowbray itself. So it's no good sitting in a manufacturing site somewhere else in the country making Melton Mowbray pork pies. You can't call them Melton Mowbray pork pies. Other examples are, for example, Stilton, Yorkshire Wensleydale, Jersey real potatoes, Cornish clotted cream, those types of things that where using the place name really evokes a strong sentiment, and those products need to be made in the vicinity of or using traditional recipes in the place. So what is the impact of Brexit on EU GIs, first of all, because the regime is an EU one? All registered EU GIs continue to have effect in the EU after the transition period, as you would expect, and that includes those with UK-based owners, so that's fine. As of the 1st of January 2021, EU GIs no longer confer protection in England, Scotland and Wales. So a slightly weird quirk here is it's not that they don't confer protection in the UK, they don't confer protection in England, Scotland and Wales, but Northern Ireland continues to be protected by the EU scheme. So how do we protect GIs in the UK? So the UK's set up its own GI scheme, and that's being managed by DEFRA. Proprietors of EU GIs existing at 11 PM on the 31st of December 2020 have already been granted an equivalent UK right. So in the same way that trademarks and designs have been cloned so that you don't lose out on protection if you had an EU registration, GIs have also been cloned. So if you had an EU GI last year, you now have an equivalent UK right. So that's helpful. I thought it would be worth mentioning what happens in relation to ongoing applications. So if you had an EU GI application that was in progress on the 1st of January of this year, that will continue to progress. And if it was granted, it will apply to EU member states and to Northern Ireland. So it won't apply in the rest of the UK. You need to apply separately to DEFRA for protection in England, Scotland and Wales. Provided you apply to DEFRA before the 30th of September of this year, so there's still time, you will be assigned the same application date as the EU GI, so you won't have lost any protection there. Applicants for EU GIs that pertain to the produce of England, Scotland and Wales are treated as applicants from third countries. That means that going forward, if you want to apply for an EU GI that applies to produce in this country, you have to have registered a UK GI before you apply for an EU GI. So that's just the order of play. If you want protection in the rest of the EU, you need to get your UK GI sorted first. And finally, a word on those 3 labels that you see at the bottom of your screen. Those are the new labels that producers with UK GIs will be required to apply to their products, depending on what type of protection they apply for. So I thought it worth just quickly running through those just as a reminder of what they mean. So the first one says designated origin. That protects designations of origin, or PDO. And that means that all elements of manufacture and the sourcing of raw materials has to take place within the specific defined geographical area that you're talking about. The second one there says geographic origin, and that is a protected geographical indication, or PGI. And this is appropriate where some of the elements of production or the sourcing of some materials might take place outside of the defined geographical area. So it's just slightly broader in scope. And then that final one says traditional speciality, and that's traditional speciality guaranteed, or TSG. These are not confined to producers of a specified origin, but are appropriate for products crafted from traditional methods or recipes, which would still distinguish them from other similar products. So now I'll hand back over to Simon, who's going to talk about customs and AFAs.
Iona. Well, all of the rights that we've been talking about, certainly trademarks, designs and GIs, are the sort of things that can be included in application for action, so-called AFA, at borders to address counterfeit goods and to seek customs seizure. However, post-Brexit, IP rights holders, as IP rights holders, you can no longer apply for action to be taken by UK border forces at an EU level, which means that you may want to review whether you have the right processes in place for customs seizure. This is because pre-existing EU AFAs filed via the EU customs offices remain valid in the EU 27 member states, but not in the UK. And pre-existing EU AFAs filed via HMRC in the UK remain valid in the UK, but not in the EU 27. Thankfully, there is a new UK system, as with the GI system, and so it's time to review whether or not you need a new UK AFA or a new EU AFA. The new UK AFA system is broadly the same as the EU one, which is helpful. And if you have an existing EU AFA via HMRC, that is effectively converted to a new UK AFA, applicable in the UK only. So how do you go about applying for one? Well, it's administered by HMRC. You have to specify whether or not you're covering Great Britain and Northern Ireland, or Great Britain or Northern Ireland. In order to file for one, you do need an EORI, or an Economic Operators Registration Identification Number. There's guidance on government websites for that. Essentially, the system of applying for it is similar to the EU one, so you need to provide details of the UK rights, but obviously in this case they will need to be UK rights only. You have to provide evidence of ownership. If you're using a representative to help you, like firm of solicitors, then you'll need to produce the authority for that. And you'll need to include lots of other information to assist in identifying counterfeits by customs officials. we've noted that a few clients were not aware of the changes here and potentially were left unprotected. So we thought it might be useful to conduct a short poll on this subject just to see whether or not this is a wider problem. So if you wouldn't mind, it would be really helpful if you could take a look at the question. Do you have a customs enforcement process in place, and have you reviewed it? Just to see whether or not our feeling is correct. Well, that's interesting. It doesn't look like anybody actually has one in place at the moment. But some that are not sure if it's applicable to us, so that's kind of interesting at full 38, 40%, maybe something to look at. Was that 38 and 63? Interesting. Okay, well, staying on the, thank you for that. Thank you for taking part on that. Staying on the subject of goods moving over borders, Iona is now going to say something on the position with parallel imports post-Brexit. And so back to you, Iona.
Thank you. So yes, I wanted to talk about exhaustion of IP rights. So just as a reminder, in the EEA, putting goods on the market with the consent of the rights holder then exhausts the IP rights in those goods. So that means once a product's on the market in the EEA, reselling that product doesn't infringe its trademark, copyright, patent, design rights. However, if a product is put on the market outside of the EEA with the rights holder's consent, say maybe in China, and it's a genuine product, importing that product into the EEA without the rights holder's consent will constitute infringement of any IP rights in that product, even though the product is genuine. So that's what's known as parallel trade. And a lot of people look to enforce their IP rights to be able to control trade in that way. So what's the impact of Brexit on exhaustion rules? So the EU's rules on free movement of goods obviously no longer applies in the UK. So from Brexit, exhaustion is no longer automatic. The Trade and Cooperation Agreement essentially left it open to the EU and UK to determine for themselves whether exhaustion of rights would apply as between imported and exported goods to and from the EEA. And where we've landed so far is that the UK government has provided that following Brexit, there will be no change. So that means if you put goods on the market in the EEA, the IP rights will be exhausted in the EEA and the UK. And so consent's not required to import those goods into the UK. However, there's no such reciprocity for goods that are put on the market in the EEA. So since the 1st of January 2021, putting a product on the market in the UK does not exhaust IP rights in the EEA. So that means you can't export goods from the UK to the EEA without consent. So you've got a little bit of an imbalance there as to where you need consent to traverse the border. So UK rights holders can't prevent parallel imports from the EEA, but owners of IP rights in the EEA can prevent parallel imports from the UK. As I've tried to remember as I'm saying this, these principles apply to registered trademarks, designs, copyright and patents, which is really important because I think we see it a lot in relation to trademarks, and I think rights holders are quite savvy in terms of knowing how to use their registered trademarks in that way. I think we see it a lot less in relation to designs and copyrights and patents. Practically speaking, what does that mean? It means if your supply arrangements involve reselling into the EEA, you'll need to ensure that you've got consent from the rights holder if you want to make sure that your goods are not stopped when they're going into the EEA. Going forward, the government has said that it plans to publish a formal consultation early this year on what the UK should do about exhaustion and parallel trade in future. So this is by no means a fixed position. Things are likely to change, and I suspect as the government starts to get its head around the various issues that Brexit's throwing up, this might be one to come to the table. So again, we had another quick poll question for you. We wanted to ask you whether your supply route includes resale of goods from the UK into the EEA. and whether you've thought about exhaustion in that context. So it seems from the results that it doesn't apply to most of you, that there are rights holders within the participants, so they don't need to think about exhaustion, and also that there are those that it does apply to but haven't considered exhaustion yet. So that's really interesting. I think if you haven't thought about exhaustion yet, it's worth having this on your radar, just because it is a moving feast and we don't know exactly how it's going to change in future. So worth just having an ear out for the changes. Thanks for answering that. I think we'll move on now to a quick word on drafting IP contracts post-Brexit. I put together this slide on drafting IP contracts, but really it applies to all contracts. And it applies to your existing contracts that are already drafted, and whether you want to go back and, or indeed have gone back and had a look at those to see whether there are any drafting errors that might impact, not errors, any drafting points that might be impacted by Brexit, or anything you might want to change because of Brexit, but equally having this in mind as you're drafting contracts going forward. I suppose one point to note is that English law is still absolutely fine for any contracts obviously in the UK, but also in the rest of Europe, because it doesn't matter which country your contract is dealing with, you can use any law. And we have actually had quite a few clients say to us, oh no, I don't want to use English law because of Brexit, when actually you need to think that through and think, if you're an English lawyer, continue to use English law contracts. That's what you're trained to work in. And, you know, English law is very clear and the courts are very sensible. So it's actually still, in my view, one of the best options. So the key when you're thinking about contracts and Brexit is to be really clear about what you can be clear about, be flexible where you can, and to preempt where at all possible any changes that might come up, so that you've already got drafting in place. So my first point is territory, and that's the obvious one. I mean, it was very easy back in the day to write the territory as the EU, and now when you look at contracts that say territory EU that were drafted prior to Brexit, you do think, do you mean EU at the point at which you drafted, or do you mean EU at the point at which you're enforcing? So it's worth being really clear on that point, and listing out the relevant countries, or saying the EU as at the date of this agreement. Just being really clear about what you mean there, because, you know, obviously we've Brexited, but other countries may well join or indeed leave the EU. So having the EU as your territory isn't entirely clear. Exhaustion, we've just talked about. Can you cover that off in your contract? Can you grant consent, or indeed explicitly not grant consent to export goods from the UK to the EEA? Where you can be flexible is in relation to pricing mechanisms. Have a think about whether you could have some kind of flexible pricing mechanism in place, given the potential for new import tariffs, VAT changes, other costs of trading. Things at the moment are pretty volatile, and it's worth considering up front whether you want to be really rigid in your pricing, or whether you can be flexible to take those changes into account. And similarly, you might want to consider conducting reviews or renegotiating prices after a certain date. If you've got really long-term contracts running with certain milestones in them, then it's definitely worth thinking about whether you should be renegotiating prices at certain points during the life of that contract, because things are likely to change over the coming sort of months and years. And then finally, can you preempt any changes where possible? So is there any key legislation? If there is, do you want to specify that you refer to that as modified or reenacted? Do you want to explicitly include any EU legislation which might not otherwise be included, or indeed specifically exclude it? So just have a think about how clear you can be and how much you could preempt any changes that might come in terms of the legislation. And then my final point is around regime compliance and procedure change. Who will bear the responsibility if existing regimes change or if new compliance procedures are introduced? Who will bear the liability and who is responsible for taking action? You obviously can't preempt everything that's going to change, but to the extent that it's possible within your sector to say, I know that that's on the horizon, or if anything does change, it makes more sense for this party to deal with it. If you can put that in the contract, you're saving yourself a headache further down the line and having to either think about it or worse, negotiate with the other side when you had thought that that was a done deal, but it was based on an assumption you had made. So always worth being clear about these things. So we had one final poll question for you. We wanted to ask you, have you reviewed your existing contracts with Brexit in mind? So there's answers still coming in, but that's super interesting because that's a fairly even split across all of the answers. I have to say, absolutely hats off to the person who said, yes, we've reviewed all of them, because I've asked this question of a lot of clients and I've not had anyone give me that answer. So well done. I think reviewing the key agreements is what a lot of people have done. And equally, you know, I absolutely have sympathy for people who are saying we'd love to, but that's just not something we have time to do or that we have resource to do at the moment. But interesting that there's a real split across all of those answers between the participants today. So thank you for that. That concludes our presentation, but we would absolutely love your questions. Please do use the Q&A function to ask anything that you'd like to ask. Really happy to answer any questions now.
Thanks very much, both. We've had a few come in already, so I'll go through those. But like Iona says, if you've got any more that you want to submit, then please do. I think the first one for Simon. How difficult is it applying for an AFA?
Thanks, Tom. It's not difficult as such. However, it's kind of quite involved to work out what you need to cover and what rights you want to include, and to sort of think about what evidence and information you want to provide so that the customs authorities can identify counterfeits properly. The online application with HMRC is a bit cumbersome online because it kind of takes you from page to page, which is not necessarily that user friendly, so you kind of have to think of everything up front, and we've got a toolkit for doing this kind of thing to help set up the process. So if anybody wants to talk about that, I'd be happy to look at it. But yeah, in short, it's not difficult per se, but you really do need to put quite a lot of thought into what it is you want to include.
Brilliant, thank you very much. Iona, should I really be reviewing every single contract we've entered into through the Brexit lens? Do you have any tips on how we can prioritise these?
I mean, it really depends, obviously, on business to business and how many contracts you've got and how practical it is and how much resource you've got. I think my tip would be, if it's not practical to review every single agreement, and it won't be for a lot of companies that enter into a lot of agreements, I would suggest starting with your top 10 to 20 most important agreements. I mean, they could be important because of the value. You know that you've got 2 or 3 really key contracts that are high stake and that the high placed stakeholders are really interested in. Stick those on the list. Any that are key to business strategy, any that are really long term, and you think, I don't know, maybe not the most key, but it's going to be around for a while, so actually worth making sure that my house is in order there. I would make a list of the sort of top 10 to 20 of those ones, and then I would make a checklist of the types of things we've talked about today, and I would just go through and check those particular points. I think I think it's unrealistic to say that you will check every single clause of every single contract, but what you want to do is just check that the bare bones of the contract really stand up to Brexit and that you've not overlooked anything that could limit your enforcement of that contract. I think it's worth thinking about as well, if you do find terms that you think actually that needs to be updated, think about your strategy for negotiation. Are you going to say to the other side, oh, these terms need updating because of Brexit, and do you want to sneak in there some negotiation points that you would also like to change in the contract? It might be the right opportunity to open up those negotiations. Obviously, bear in mind that if you do that, that opens up the opportunity for the other side to negotiate the contract in their favour or on points that they might actually want to change at this stage. So if that's not appealing, be really clear when you say to the other side, we need to amend these specific key points because of Brexit, and we are not opening up any negotiations further. So give that some thought and be really clear as to which side of the fence you're sitting on there. Do you want to open up negotiations more generally and use this as a key to do that, or do you actually want to limit your changes to Brexit only?
Okay. Thank you very much. Simon, you mentioned reviewing watching services. What watching services should we review?
I think I was talking primarily about trademark watching. So this is where you watch for third-party trademark applications that the rights holder might want to oppose. There are many platforms that are continuing to include the UK as part of their EU-wide watches, but I think that's going to change in the future. So trademark owners will need to consider whether or not they need separate watches for the UK and decide which territories are the most important, really. I mean, if anybody's on the watches with us, then obviously we'll be in touch. But otherwise, happy to provide any more information. There are lots of types of watching services, but in this context, we're really talking about trademark watching.
Perfect, thank you. I'm just conscious of time, so we'll probably do one or two more questions and then we'll wrap up. So, Iona, do we know if the UK government is likely to implement similar legislation to the Copyright Directive?
That's a good question. So I don't think we know at the moment. It is possible that they might opt to do that. I seem to remember that the Digital Culture, Media and Sport Committee announced later during the course of last year that it was going to launch an inquiry into the economics of music streaming. So that obviously feeds into an element of whether we need sort of equivalent legislation to the Copyright Directive. So we don't know where that will go and what that will lead to. A separate piece of legislation that's being put forward at the moment, which you may have heard of, is the Online Harms Bill. And that was first proposed well over a year ago, probably nearly 2 years ago now. And that is a plan for a new system of accountability for tech companies. So going beyond the sort of self-regulation that we're seeing at the moment. That bill actually proposes a duty of care between tech platforms and their users. So it's not quite what the Copyright Directive is doing, but it's heading in the same direction of trying to regulate that area and realizing that tech companies actually have got a lot of power, and with that we need to be imposing maybe more responsibility on them than we have done to date. I think the really interesting thing about the Online Harms Bill is that they are proposing that there would be substantial fines for breach. So I think it was up to a maximum of £18 million or 10% of global turnover. So we're seeing, fines equivalent to the GDPR sort of style fines. And they're also talking about potentially extending it to criminal liability for senior individuals if there was a major breach. But I mean, I suppose the point I'm making is it's quite serious stuff. So if you are in that line of work, which is, tech platforms or working with tech platforms, it's one to keep an eye on.
Great, thank you very much. And finally, Simon, you talked about the deferred publication for designs. What is this?
Okay, so deferment is where you delay the publication of a registered design application. Most often it's probably favourable to have immediate publication of design because the design registration is effectively a deterrent against copyists. However, there are times where you want to defer publication of design, say for example where you might have a corresponding patent application that you need to keep secret because otherwise it will destroy the novelty of the patent application. Or maybe simply from a purely commercial standpoint, you want to control the launch of a product to which the design relates, in which case you might want to keep the design secret for a period of time. I think I was talking in the context of difference in the deferment period between a UK registered design and a registered community design. Which is 12 months for the UK and 30 for the EU. I think, you know, if the shorter period in the UK is a problem to people for any one of those reasons, then there are strategies to try and extend that period, maybe by using priority periods or similar, but I'm happy to talk about that with anybody who's interested.
Brilliant. Thank you very much. So just finally, thank you both to Simon and Iona for your time today. Thank you to everyone that's attended today and any of the other Brexit webinars that you've attended. The recording will be shared later on today or tomorrow with all the attendees. Finally, thank you again and enjoy the rest of your day. Thanks very much.